Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at the Oxford Handbook of Legal History. It's a massive subject area. It's been edited by Markus D. Dubber and Christopher Tomlins, and of course it comes to us from Oxford University Press. It's a formidable work. We're going to have a look at it in a minute. I love the wise old owl on the front cover. We'll talk a little bit about the book. I'm not going to give any spoilers. The reason I'm reviewing this work is because I think it will be of great benefit to many people doing both history and law, and the history of law itself, which is not very well, it's not a particularly popular subject amongst undergraduates, but I do think it's an important area and one I've always been fascinated in because of the way in which the common law has developed over what is shortly going to be 1,000 years. Now, what do we say about the book for our review? Well, Elizabeth and I talked about the book, and we've given the title High-Level Conceptual and Thematic Statements Across Our Legal History. And it comes to us from Oxford University Press. Now, I'm using that because it's effectively a quote from the Handbook. Let's have a look at it first of all. It's a big book, very much the the house style for OUP. There's the front, there's the spine, and then there's the back. Very large number of contributors. In the inside cover, you've got information about the books in the series and some blurb about some of the people concerned and what the series gets up to. And at the front, basically some information about the book. It's quite important. It also says very little about the authors apart from basically a couple of lines. The back of the book, of course, let me just show you, is a very substantial index by page numbering. A lot of information, and most of what you may be looking for you should be able to find in the index. I felt it was a very, very substantial index, and of course you've got there the back at the end part of the bibliography. Again, huge amount of work has gone into this work, and I'm very grateful to everybody who has participated, because what you are getting with each of the chapter headings is a bibliography at the back of each one. Actually, you get an introduction, a middle bit, and a conclusion with most of the chapters, and I think that's very helpful. Now, moving to the front of the book, that's the front page there, which you can see. It's a heavy book. It runs to nearly 1,200 pages in total. Got the blurb from OUP, and then you've got a very useful editor's preface, which is worth reading. It's talking about how long it's taken to actually produce this book. Our goal was never a handbook of law across time and space. It can't be, basically, but I think what they've produced in one volume, it captures the glorious variety of research on legal history going on around the world today. And that's what I found, I think, most interesting about it, because we said high-level conceptual and thematic statements across our legal history, but it's everything, which is contained, if you look, in the contents section, which is there. Again, it looks contents, locating legal history, approaches, conceptualising, legal history and modern legal thought. Each chapter heading, of course, is by an individual contributor. You've got specific people mentioned. You've got Jeremy Bentham, Blackstone, you've got historical jurisprudence. Also, everything that you can think of is basically there. Marxism, of course, plays a big place. Then you've got traditions tracing legal history, which I found quite interesting because that's Roman law and a whole range of other ones. Jewish law, Islamic law, tracing legal history, Aboriginal rights, and so forth. So you've got Indian law, you've got everything that you want in that particular part. Then illustrations, doing things with legal history. And that's really trying to see if we can get any conclusions out of what has been happening, if I can put it as crudely as that. It's obviously far more detailed than that. Historical analysis in criminal law, a counter history of criminal trial verdicts, for instance. And then right at the end, genocide is looked at, for instance, and foundings, European integration. Bit unfortunate, I'm recording this just prior to the British withdrawal from the European Union. Now, this is notes on the contributors, a very large number of them, some of whom will be very well known to you. You can see the names of the people from the large number. Of course, the book is not the easiest book in the world to hold, but you can see the names of people. very large number. I can't go through all of the names, but there are a large number of people. Then you can see the structure. Part 1, context, locating legal history. Then you get into the individual chapters, and you've got detail about who the person is who's written the particular chapter, and details about him or her. Then an introduction, as I say, and then you run through, and then you get, after that, at the back, you get a conclusion, normally a conclusion of some sort. There we go. And then you've got, in addition to that, a limited bibliography per chapter. Now, that's basically the book. As I say, it's a heavy book in all senses of the word, because this is not a book for people who have no knowledge of the legal world or legal history. And, of course, for people such as myself who have a number of legal qualifications, I found it actually very interesting, but basically mainly because I've actually already achieved quite a lot academically, and of course I'm a practicing barrister, which helps because I can understand the historic compartments into which some of these areas fit when we look at how the common law, for instance, developed in England and Wales. So what do we say about the book? Well, partly it comes from what's actually said already, and that is that the study of legal history remains ignored in many teaching circles because it's seen as boring. Not so, in our opinion. And we're delighted to read this new handbook from Oxford University Press, as I said, very much in the style of their other handbooks, and I think a gem for research purposes. It's concise, detailed, and has the benefit of 59 main contributors, which attempt what many may consider the impossible: a complete analysis of our legal history in just over 1,000 pages. Now, I say that because we've had a number of different types of subject matter that's been looked at. Bertrand Russell looked at the history of Western philosophy. John Bowl looked at the history of Western political thought. We've had these approaches when it's looking at the history of these particular areas, but nothing quite like this, which is why I would like to thank the editors, Markus and Christopher Tomlins, very much, because they described the purpose of their compilation of writing that some of the most exciting and innovative legal scholarship has been driven by historical curiosity. Exactly so, because in fact it's nice to see the perspective whereby you've got a set of legal rules and decisions. You want to know how they've arrived at them. Now, I know that some people don't think that's particularly relevant. I think it is. I certainly think it's relevant in things like the development of land law and equity, for instance, and in many other areas. However, it depends on your point of view. But it is that historical curiosity which I think many of us have as researchers, rather more than just as practitioners. And we would add that quite often the history of law has been given insufficient emphasis in the past, except when one studies land law, which I've just mentioned, which has always been the cornerstone, of course, of legal dispute in so many jurisdictions, and of course led, when they didn't get the remedies they wanted as litigants, to the development of equity. And of course, always throughout the whole of that period was the very heavy link with religion. Now, Doomer and Tomlins view legal history today by what they call as a fascinating array of shapes and sizes. They call it that, from micro history to global intellectual history. So the breadth of research is a rather tall order. Again, I said it was boring earlier on. I'm afraid that probably is perceived to be the case by many. I don't find it that, but certainly other people do. Legal history, of course, the editors go on to comment, has expanded beyond traditional parochial boundaries to become increasingly international and comparative in scope and orientation. Here. I mean, we've got to actually compare what we do with what other people do because of the fact that we are in this global society now, which has come upon us actually quite quickly, and many legal systems haven't really been able to adapt at all to what has happened, and of course it will take time. Thus, the title justifies our view, we say, of the rising importance of legal history in the 21st century. And the handbook, of course, is based on scholarship from across the world. The contributors offer a variety of methodological approaches from their areas of expertise and their own research agendas, and we benefit from that. is rightly described as a timely compendium which takes and evaluates legal history and methodology anew, with high academic commentary throughout on the various modes of the historical analysis of law, past, present and future. And of course, as I've indicated, the final part of the book gives some indication of whether we've learnt anything, because you remember the old phrase, history repeats itself. Well, it does. It does. And the fact is, do we learn anything? We do sometimes, but not always. Let me conclude by saying this. The handbook, looking at the structure of the handbook, it's divided into 5 parts. Part 1 looks at the relationship between legal history and its related historical perspectives from economic, philosophical, sociological and comparative studies to both literary and rhetorical approaches. Part 2 then goes on to consider various approaches to legal history, which we feel students will find highly informative. I certainly did. It looks at things like Roman law and so forth. Part 3 goes on to focus upon the interrelation between legal history and jurisprudence by investigating the role and conception of historical inquiry in various models, schools and movements of legal thought. So you're getting very much the jurisprudential arguments coming to the fore. In other words, what we're looking at there is aspects of the philosophy of law. Part 4 considers the place and pursuit of historical analysis in various legal systems and traditions across time, cultures and space, hence the historic analogy. And the last part, part 5, as I've said, and it's a theme running through, is it offers a clear focus on the exploration of several examples of legal history over the years, plus how it can be used in various legal doctrinal contexts. So we thought when reading this work that the contributors had sought to climb a particularly high hill with their subject matter. And unlike Sisyphus, the team have completed their trip around legal history, in our view, brilliantly, as, to use a phrase, they've thankfully left no stone unturned. Thank you for this splendid research. So they're not pushing any more stones up hills. What we've got here is a very substantial work, which I think is a great reference work and of interest to, I think, a wide readership. And the publication date is cited as at the 23rd of October 2018, and in fact that's about the time I'm reviewing it. One quite last look at the book. There it is again. It is a heavy book, hardback there, spine and then so on, and then just opening it in the middle, Feminist Historiography of Law. There we go. That actually dealing very much up to date with some of the problems we have. Introduction, or what's in a name. What did this mean for a woman? So we're looking here very much at the suffragette movement and all the other problems associated with feminism, both in jurisprudence, in criminology, and across the board. Another one we've got here, medieval canon law. Now that takes me back to when I was doing A-level law, which is 50 years ago. In fact, over 50 years ago. Medieval canon law being of course, very interesting. And when I was that age, I didn't really understand very much about it at all. I've learnt a lot even by reading this book, because it gives me that information which I probably was lacking. But again, it shows you where it fits in to the overall pattern of things. The transformation of the common law in the 20th century, and so forth. Now, without going any further, you can see the value of the book. Now, obviously, you've got to be enthusiastic about history, enthusiastic about law, but the bottom line on it is it's a very good book. And the wise old owl at the front indicates that you should read it. So a big thank you to all the contributors and the editors, and of course to OUP, for another excellent book. Delighted to be able to review it. So thank you all very much for your hard work. Bye-bye.